And welcome to the Employment Law Show. John Scholes, Lior Samfiru. Want to reach out to 1-855-821-5900, help at employmentlawyer.ca, or shorten that to employmentlawyer.ca online to check out the website, catch past shows, and listen to our radio show as well. Lots of good stuff on the show today, Lior. We're going to talk about the difference between terminations and layoffs. That is coming up here in just a bit, and the Pocket Employment Lawyer. You can visit that as we sit here and idly chat, pocketemploymentlawyer.ca, but we'll get to some details here very shortly. Pal, how are you? What's going on with the week that was?
I am doing great. Good. I'm always excited to be here. I'm always excited to talk about employment law. You know, I've had more and more situations where someone sees me on the street, they stop me and they say, you know, I really appreciate you giving out this information. It's helped me out. It's helped my friends out. That's terrific. That's what we're here to do, and that's what we're here to do on every show, to hopefully give that information to people, to help them understand what their rights are. Because when it comes to employment law, the law is quite good. The law is extensive, so you may not realize it, but you have extensive rights when it comes to employment law. Your job, your rights on severance, your rights if you're discriminated against or harassed or bullied. The law is quite good, so take advantage. Listen to us. We're going to tell you every week what you need to know. But let me tell you about a situation that came across my desk. And unfortunately, Don, I'm going to spoil it a bit here. This one does not have a happy ending. I usually kind of pick these stories that have happy endings. This one doesn't, though. And this goes back to my old good buddies at the Ministry of Labor. And our regular viewers know, I've said this before, if you lose your job, when it comes to your entitlements, you cannot go to the Ministry of Labor. And let me tell you why, and let me give you a story that came across just a few days ago. I got a call from an individual who, after 6 years of employment, was let go. The company made some nonsense allegation of just cause. They said, we shouldn't have to pay you severance because you did something wrong. It was nonsense. Well, he filed a complaint with the Ministry of Labor. As soon as he did that, company wrote him a check for 6 weeks' pay. Ministry of Labor says, okay, that's all you get. We're going to dismiss the matter because they paid you what you owed you. So he called me and he wanted to know, is that right? Is that what I'm owed? The 6 weeks' pay after 6 years of work? John, you're saying, oh boy, because you know. Nonsense. Of course that's not what he's owed. I assessed him as being owed 8 months' pay. Months, not weeks. But the problem is, because he filed a complaint with the Ministry of Labor, he's now prevented. He's prevented from pursuing his entitlements. He cannot go after his full legal entitlements, which are 8 months' pay, just by filing a complaint with the Ministry of Labor. So that's what happens. If you're working, if you lost your job, the worst thing you can do is to file a complaint with the Ministry of Labor. Then there's two reasons. The first reason is the Ministry of Labor can only help you enforce your minimum entitlements, not your full entitlements. So that's really a small fraction from what you're actually owed. That's number one. And number two, as I've just said, just by filing that complaint, you can't withdraw it unless you do it within 2 weeks, and you're prevented from actually pursuing your full entitlement. So you're giving up 80–90% of your rights. A terrible situation to be in. So if you lost your job, give me a call, send me an email, go to Pocket Employment Lawyer, go to a fortune teller, do anything other than going to the Ministry of Labor. You can't do worse than that. So if you want to know what you're owed, that's what you do. Don't go to the Ministry of Labor.
If someone's watching us, the show right now, think, oh man, I just filed with the Ministry of Labor. Do they have a little bit of a window to take it back? Can they pull it back and say, I didn't mean to?
2 weeks.
That's it?
It's a tiny window. It's pretty darn tight. Yeah. You have 2 weeks to withdraw that complaint. Right. If it's more than 2 weeks, you're now barred from pursuing your entitlements. A very bad situation to be in. And John, I just told you about a case. I've probably seen dozens and dozens of these types of cases over my career where someone filed that complaint because they didn't know better and gave up their rights. Again,
employmentlawyer.ca to find a radio show near you. Listen back to some of the past ones and catch them weekly. Going to take a first phone call from the show and talk about it right now here.
A friend of mine works in a small retail store inside a grocery store. They don't allow the employees to leave the store. If you're working a Saturday, you're working 7-8 hours, you have to stay in the store, eat your lunch in the store. Right. Customers are coming in, and we kind of feel like, well, that's not right. Should you not have a 15-20 minute break, leave the store, put a sign up? What's your legal rights?
Yeah, that's wrong. Yeah. It's wrong on a human level, but let's put that aside. It's also wrong on a legal level, simply because you're supposed to get that 30-minute break. It's not paid. The company doesn't have to pay you for that break, but they have to give you that break after 5 hours of work. So in this case, if the company refuses to give you that break, they're breaching the Employment Standards Act. They're doing something illegal. So there's two things that can happen here. Mm-hmm. The first thing is he can actually file a complaint with the Ministry of Labor. And I just finished telling you why you shouldn't file a complaint with the Ministry of Labor, but that's only with respect to losing your job. If you lose your job, you can't file a complaint. Pretty much for anything else, if there is an issue, you could try to go with the Ministry of Labor. And in this situation, if your employer doesn't give you a break that they're supposed to give you, you can file a complaint with the Ministry of Labor, and they'll come in and they'll enforce your rights and make the company give you a break. The other thing you can do is this. Your employer is breaching the law. They're doing something illegal. They're not treating you in a legal way. You can treat this situation as a termination. You can treat that as a constructive dismissal. Your employer doesn't comply with the law. You don't have to accept that. You can say, I'm out of here. I'm going to treat the situation as a termination, pursue my severance, and leave on those terms.
PocketEmploymentLawyer.ca. We love this website. It's been up for several months now. It's gaining a lot of traction. Rolled into that, we'll talk about is the severance pay calculator, which had so much success. Again, PocketEmploymentLawyer.ca. Tell me about it.
Well, you know, we're here on TV on the weekends. You can watch us and learn about employment law. But what happens if you have questions and it's midnight on a Friday and I'm not on TV and I'm not in the office? Well, PocketEmploymentLawyer.ca. It's like having your own employment lawyer with you 24/7 on your phone, tablet, desktop, what have you. So when you go to PocketEmploymentLawyer.ca, you're going to be able to get your severance analyzed. It's free, by the way. It's anonymous. Find out how much severance you're owed. You're going to be able to find out if the company had cause to let you go, if you're an employee or an independent contractor, if your case is considered harassment or discrimination, and more. So it does the main things that I do. We've tried to automate it as much as possible. Anonymous, I said. Free, I said. Easy to use. There's no strings attached. First place you go to, John, if you have an employment law issue, even before you give me a call, is PocketEmploymentLawyer.ca.
Want to refer to a listener and a caller, for that matter, from the radio show who sent this in, and we'll run this through the PocketEmploymentLawyer.ca website. It says, Radovan says, my performance has declined due to constant harassment and abuse from management. I've reported the issue multiple times, but nothing's been resolved. The abuse has forced some coworkers to quit. My manager says I should join them if I'm not happy. Wow. That's nice.
Wow. And makes me shake my head. And let's, before we even put this into the Pocket Employment Lawyer website, let's make it very clear that we all have a right to work in a workplace that's free of harassment. It's one of the most basic rights that we have, to be in a harassment-free workplace, to ensure that we're treated properly. And it's the company's obligation to make that happen. So if you're working in a poison work environment, if someone's mistreating you, you should tell your employer, HR, the owner, give them that opportunity to fix that problem, all right? And if they don't, that could be a constructive dismissal. In some situations, it could be a human rights violation. It's illegal. You should not be harassed. But if you want to know, just like in this situation, if your matter is considered workplace harassment, let's take the information from what you just read, John. Let's plug that into PocketEmploymentLawyer.ca. So we would answer those questions there. You know, the length of time that the person worked, 2 years. Who is he being harassed by? In this case, it's a manager. The type of harassment, we put that under the category of unprofessional treatment. And then, did he ask for help? Yes. And is he employed? Yes. Well, the PocketEmploymentLawyer.ca, you can see that on the screen, says that this appears to be an inappropriate harassment situation. Since you gave your employer the opportunity to fix the problem, you may be able to take legal action. Right. It is harassment. You gave the company the opportunity. Now you can take legal action. It's that easy to use. So check it out for yourself, PocketEmploymentLawyer.ca.
Does that change at all if the person harassing is the person you're supposed to report to, if it's the boss doing it or the owner of the company?
Yeah, if there really isn't anyone to report to, then you really can't do anything about it. So in those situations, you may be able to take legal action even before or without having to report. If the owner of the company is harassing you and it's really just you and the owner, who are you going to report to? But in most cases, if at all possible, I want to try to give the company the opportunity to fix the situation. And if they don't, yeah, there's definitely legal recourse.
Coming up here, the difference between terminations and layoffs. We'll get to that. Stick around. Don't go anywhere. 1-855-821-5900. EmploymentLawyer.ca is the website. More of the Employment Law Show is coming up. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurance to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. I want to talk about this, the difference between terminations and layoffs. It's for the layman who doesn't do the show with you for the past 8 years, they don't know the difference. It sounds like it could be the same thing. So we'll break it down. What is a termination?
So it is different terms that people use, but they're not legal terms. So we want to talk what the law says about those situations. So a termination is any situation where you lose your job involuntarily. In other words, when the company decides that you're not going to be working there, that is a termination of employment. Obviously, the difference, the opposite of that would be a resignation. Resignation is something that you do voluntarily, unilaterally. But if the company decides, if you're not wanting to leave, the company made the decision for you, that is considered a termination of employment. That is the correct legal term to use if you lost your job.
Is there different types of termination, with cause, without cause? We hear those terms being thrown around all the time, right?
So the most common form of a termination, what people refer to as layoff, that's not a layoff, we'll talk about layoffs soon, is a termination without cause. A termination without cause is simply a situation where you've been let go, not because of anything bad that you did. Maybe it's a restructuring, maybe it's a cost cutting, maybe the company has decided to go a different direction or to outsource, what have you. That is a termination without cause. So the most common situation, most people when they're let go, it's a without cause termination. And the importance of that is, of course, if you've been let go without cause, you get your full severance. And we'll talk more about that. The other type of termination, there's really only two types, is a termination for cause. A termination for cause, what often people refer to as being fired, is a situation when you're let go because of something terrible that you did. Now, it's very, very difficult to establish cause. The company would have to show that what you did made it impossible to continue employing you. That's very difficult. So maybe you stole, maybe you hit someone, maybe you sexually harassed someone. Then you can be let go for cause, which means you don't get severance. What I want everyone to understand when it comes to termination for cause is that in most cases, 3/4, 90% even of cases, when someone is supposedly let go for cause, that's not really cause. The company pulled the trigger before they should, which it means in the eyes of the law, that's a without cause termination. So if you've been let go, it's either a with cause or without cause termination. And if the company says it's cause, unless you did something awful, that's probably wrong, which makes it a wrongful dismissal.
By the way, reaching out anytime as we go here, 1-855-821-5900, help at employmentlawyer.ca. The difference between terminations and layoffs, so that leads us to the layoff. What is it?
So from a legal perspective, a layoff really is a situation where you've been let go, but not really permanently, or it's a temporary situation. We call that a temporary layoff. That's the only layoff that the law recognizes. So a temporary layoff happens when an employer says, we're just going to, as you like to say, put you on ice for a while. We're not actually letting you go forever. We're just going to have you stay at home for a few months. Maybe business is going to pick up, and then hopefully we can bring you back. It's a temporary layoff. That said, a temporary layoff in most situations is actually not allowed. A temporary layoff in most situations is considered a termination. So even if you've been laid off temporarily and the company says, no, we're not letting you go, you, the employee, may have the right to treat that as a termination and say, no, I'm not accepting that. I'm going to treat this temporary layoff as a termination and make you pay me my full severance. If you've been laid off temporarily, no, the company in most cases doesn't have a right to do that. If you want to know if they do or they don't or how much you're owed, always feel free to call me, email me, and let's talk about it.
You said right there, and I was going to ask, does the employee have to accept it? Is there a situation where they might have to accept it?
So in most cases, as I said, you don't have to accept a temporary layoff. You can treat that as a termination. There are some situations where you have to accept it. The most common is a situation where the company's done it before and you let them do it. In other words, you've accepted it. You didn't have to, but you did. by allowing them in the past to lay you off temporarily, you've now given them the right to do it again in the future. And then the second time, third, fourth time they do it, you may not be able to treat that as a termination. There's also some industries where a temporary layoff is assumed. For example, in construction, if you're building seasonal workers,
yeah.
It's assumed you're going to be off or laid off over the winter. But for most jobs, most full-time permanent jobs, a temporary layoff is a termination, which means if you are laid off temporarily, you can get your severance right now.
So if I'm a victim of this layoff termination, how much severance am I owed? Is it different from a normal termination?
No. So a temporary layoff results in a termination, which means you get your severance like in a termination. And remember, the factors that go into assessing what you're owed, whether it's a temporary layoff or a regular termination, is your age, your position, and the length of your employment. The easiest way to find out how much you're owed, just go to pocketemploymentlawyer.ca, input your information, find out how much you're owed. The first place you go to, you have that severance letter in hand. They said they're going to pay you 6 months. Is that good enough? Is it not? No need to worry or wonder. pocketemploymentlawyer.ca.
It's funny, we always say it too, you wouldn't expect or accept a 50% pay cut if someone came and offered you that, your boss, but a layoff, it's a 100% pay cut, and you go, okay, I'll sit at home for a bit. No.
But there's a lot of misleading information out there, and that's the problem. Even the Ministry of Labor, we talked about that at the top of the show. If you call the Ministry of Labor, they'll say, yeah, they can lay you off temporarily, because in some situations it's permitted, but under our common law, I'm not going to get too technical here, it is illegal. So there's a lot of misleading information, but if you're watching us now, you heard it, you understand, a temporary layoff is a termination, not something a company in most cases is allowed to do.
The place to go, employmentlawyer.ca. Every time you want to catch a place to find our radio show, listen to the radio show, as we do that every week and have been for about 8 years now. I think we're coming up on that. We take the phone calls from the show and we talk about them here. Phone call number 2 is right now.
I worked at a company for 26 years. All they gave me was a lieu of notice, 8 weeks, and a reference letter, and that was it. And I was wondering, if I applied for unemployment insurance, does that mean I automatically accept what the package that they gave me? It just happened 2 weeks ago. I had a friend help me write up a letter asking for a certain amount, and if I don't hear from them, I told them I would seek legal advice.
Wow.
That's an interesting question. People would say, if I get on EI, is that it? Am I done?
Yeah, and so this guy, after 26 years, was offered 8 weeks pay. And so I'll talk in a second about what he's actually owed. But to his question is, okay, I was offered something. I don't want to accept it. I think I should be getting more, but I need to live in the meantime.
Right.
So I want to apply for EI, employment insurance. If I do that, does that mean I've accepted their offer? The good news is absolutely not. You can and you should apply for EI, and the fact that you've applied for EI does not mean in any way, shape, or form that you've accepted what the company's offered. Those are separate things. You should always feel free to apply for EI. You should do that as soon as you lose your job. There's no downside to that. In fact, if you don't apply on time, you may be given a hard time later to qualify. Always apply for EI. But to me, frankly, the more interesting thing is, what is this person owed after 26 years? Wow, that's a long time. He was offered 8 weeks. Well, I think the technical term for that is nonsense. Of course he's owed more. So rather than me just tell you how much he's owed, which I can do, let's just plug that into pocketemploymentlawyer.ca so that anyone in that situation or a similar situation can find out how much or how easy it is to use. So if we're going to go to pocketemploymentlawyer.ca, we'll put in the person's position. Let's say he's a supervisor, 26 years of service. So we'll put in his age. He was offered 8 weeks, and we see on the screen he's owed somewhere between 22 to 24 months. Not weeks,
2 years.
Months pay. Up to 2 years of pay instead of the 2 months that he was offered. Depending on his salary, that's going to be tens, maybe hundreds of thousands of dollars in extra severance. That's how easy it is to use. And don't accept anything less. Don't accept anyone else's advice. You got to go to a professional when it comes to these things, or just as easy or easier, pocketemploymentlawyer.ca.
Coming up here, we get to being penalized for not taking more shifts. We'll talk about that after a short break. It's employmentlawyer.ca is the website, or 1-855-821-5900. Employment Law Show. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. It's the Employment Law Show, and employmentlawyer.ca is the website from which we get our phone calls because we do a radio show, and you can find past shows there as well. We'll get to phone call number 3 for today right now.
I work for a fairly large municipality, non-unionized. I've been there 5.5 years. When I started, we did not have any stipulations on how many shifts we had to provide or had to work per month. And now they've recently changed it for all new hires. They have to work minimum 7 shifts per month. So now my manager is trying to come down on me, saying that I need to fall in line with the way the new regulations are. For this month, I was given 0 shifts. The manager told me that I should see whether or not I'm a fit for the company still.
Nice.
Wow. Yeah. Why do companies do that? I mean, in what world can they actually do that legally or get away with it? It's silly. So let's break this down a bit. So he's working, he has his shifts that he's working, number of shifts that he's expected to do, that's fine. He's been doing it for a while. On and on he goes. Yep. Then the company says, now we want something different. Now we want you to work other shifts, more shifts, different shifts. Well, guess what's happening there? The company is the one changing the terms of employment, and the company does not have a right to do that. Your employer does not have a right to make significant changes to the terms of employment. And in this case, is to tell them, hey, we need you to work more shifts than you have been. You're not working enough, or different shifts. That is a big deal. Changing your work hours, your shifts, that's a huge change. And he doesn't have to accept it, and he can't be penalized for doing that, for refusing to accept it. So he's done nothing wrong. In fact, the company here has done something wrong. Whenever we're talking about changes to shifts, changes to hours, to compensation, to the terms of employment, we touch on the topic of constructive dismissal. So I told you that this is a constructive dismissal, but we can also go to pocketemploymentlawyer.ca. Let's give it another run, and let's see how that works in this particular situation that we took the phone call from. So we'll answer the questions there. He's worked there for 5 years. The company's changed his days or hours of work, and we see the result that type of change is a significant change and often results in a constructive dismissal, which would allow you to leave with your full entitlements, full severance. Yeah. That's how easy it is, and that's exactly what I told this person when he called us on the show. No, company doesn't have a right to do that. You have been constructively dismissed if they impose this on you. Same for you. If your hours, your shifts, your days of work are being changed unilaterally, you don't want that. It's not something that works for you. The company does not have a right to do it.
I guess the only caveat or caveats to that would be if they've done it before and he'd let them do it, or if it was in his original employment agreement. We can change your shifts when we want, right?
You're paying attention, John. Done. Mic drop.
It's over.
It's over.
Roll credits. We're done.
That's it. It's over. Thank you. No, but that's absolutely correct. Right? If your employment agreement, which is an extremely important document, if your employment agreement gives the company the power to make changes like that, then they can. If you sign an employment agreement saying, we can change your hours of work, we can add or reduce your shifts, then guess what? If the company goes ahead and does that, well, they're not doing anything illegal because you've given them the right to do it. So we always want to look at your employment agreement. And the same thing, if you've been the good team player before, you've let them change your shifts, now arguably they can do it again. So when it comes to changing your hours of work, changing the terms of your employment, you really do want to stand up for your rights. If you don't, you may regret it later.
Another place for you to go to ask questions, get more information, terminationquestions.com. We'll get to our first question from the day from that. Austin writes in, says, my company merged with another one. We're all now in a 3-month probation period. Is that allowed?
No, it's not allowed. You absolutely can't be. Listen, if even a company merges, or if the company is sold to another company, you continue working, they inherit your service, which means all the service you had previously is still there.
Right.
So they can't eliminate that service by putting you on probation. If you're an existing employee, whether it's with the same company or maybe a company's merged like in this situation, or company is sold and you continued working with the buyer, you cannot be put on probation legally. It's meaningless. You've already established yourself. You have a certain amount of seniority, and because of that, the company does not have the ability to put you on probation. And if they try to, honestly, it's meaningless.
Right.
They're not going to be able to say, oh, you didn't pass the probation, so you're out of here. You cannot be put on probation if you've already passed the probation.
Again, terminationquestions.com is the place to go for these. Lori's next says, can I look for another job while I'm still employed? Would they legally be able to fire me if they found out what I was looking at and opportunities elsewhere?
So there's nothing legally wrong with looking for another job while you're working for a company. Now, of course, as long as you're not spending all the time when you should be working on, Indeed, for example, looking for jobs. But if you do it on your own time, there's nothing wrong with that. Here's the thing, though. She's also asking, can my employer let me go because of this? Well, even though she's done nothing wrong, her employer can let her go simply because an employer can let you go pretty much for any reason as long as severance is paid. So her employer can say, you know what, I'm not happy that you're looking for another job. I'm kind of upset at it, so I'm going to let you go. They'd have to pay full severance, absolutely, but that is legal. What they can't do is they can't say, oh, no, that's misconduct, so we're going to let you go for cause. We're going to let you go and not pay you any severance. Absolutely not. They cannot do that. But yes, she can be let go with severance as long as she gets paid exactly what she's owed.
We'll get Shane here. Again, terminationquestions.com. If you want to use this resource anytime, you can ask your questions as well. They might appear up on the show. Pardon me. Shane says, can my employer fire me immediately without warning? I thought they had to give you a standard 2 weeks notice ahead of time. I think he's got that mixed up.
He does, except here's the thing. As long as he gets paid his severance, yeah, he can be let go with warning, with no warning, at any time because it's Tuesday or because he likes blue cars and the company only likes people with red cars. So he can be let go. What the company cannot do, as I said earlier, is they cannot let him go for cause, usually unless they give him some warnings. So the company can't say, wait a second, your performance is bad, so we're letting you go for cause, unless they've built up their case, unless they give him a warning, they gave him an opportunity to improve, they gave him a second opportunity, and then if he's still not getting it, maybe then they can consider letting him go for cause. But can a company, without warning, even though you've done nothing wrong, let you go? Yes, but severance has to be paid. Now, we hear the term wrongful dismissal often.
All the time, yeah.
Wrongful dismissal really is a situation where a company lets you go and does not pay you the full severance. It really has nothing to do with the reason. The reason could be perfectly legitimate and legal. You could still be wrongfully dismissed if the company didn't pay you your severance. That's what we're talking about when we talk about wrongful dismissal. Remember that most of the time, John, when I speak with someone, they lost their job, they want to tell me that the company did something wrong because they should not have been let go.
Right.
The company was wrong in letting them go. Unfortunately, the company is not wrong legally. They are allowed to let you go, but where they may be wrong or may be doing something illegal is by not paying you the full severance that you're owed.
Let's flip it around quickly, though. Shane writes to mention 2 weeks. If you're resigning from a job, is there a standard or legal amount of time you should give your employer? 2 weeks?
There really isn't. The law doesn't get involved with that too much. It comes down to what's in your employment agreement. If your employment agreement says if you resign, you have to give us 2 weeks notice or 3 or 4, then that's how much you have to give. So look at your employment agreement. If there isn't anything in the employment agreement, be reasonable.
Be cool about it.
You don't want to burn any bridges. Don't tell your employer, I'm gone tomorrow. Give them some notice so they can find someone. But in terms of what you're legally required to do, it's what's in your employment agreement. Sometimes it's 2 weeks, sometimes it's 4 weeks. That's what you have to follow.
All those previous questions from terminationquestions.com. You can reach out, help@employmentlawyer.ca. That is the email address. You want to catch past shows or a radio show as well. That is simply employmentlawyer.ca. And we talked about it, used it, referred to it several times as we do every show, pocketemploymentlawyer.ca. There's all kinds of ways for you to reach out. Thank you for joining the show. Phone number, simple, 1-855-821-5900. We'll catch you again on the Employment Law Show. Thank you for watching.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.